Good morning. This is Stan Stahl of SecureTheVillage, and welcome to our webinar, The Basics of Cyberlaw. I'm your guide, and got a very auspicious panel with us today. Bennet Kelley of the Internet Law Center, Cyberlaw and Business Report, Tom Peistrup, General Counsel at InStyler Milano, Tim Toohey, a partner at Greenberg, Glusker, Fields, Claman, and Machtinger, and Mike Zweiback, a partner at Zweiback, Fiset, and Coleman. Bennet, why don't you lead things off and introduce yourself?
Hi, I'm Bennet Kelley. I'm the founder of the Internet Law Center, which is a firm in downtown Santa Monica, and I'm also a host of Cyberlaw and Business Report, which airs weekly on webmasterradio.fm every Wednesday at 10 a.m. Pacific.
Great. Thanks, Bennet. Tom?
Tom Peistrup. I have a couple of roles. I'm general counsel of two consumer products companies, including the InStyler collection of companies. My background is in intellectual property and litigation, soft IP and litigation. And I also have a private law practice.
Super, thank you. Tim?
Yes, I'm Tim Toohey. I'm at Greenberg Glusker. I'm a partner in our intellectual property and privacy department. I specialize in privacy, data security, including both United States and EU privacy and data security.
That's great. And Mike?
Hi, I'm Mike Zweiback, and I am founder of the recently founded Zweiback, Fiset, and Coleman law firm. Prior to that, I was the head of the National Security Practice Group at Alston & Bird, and before that, I was an assistant U.S. attorney and chief of the intellectual property crime section and cybersecurity law section.
That's great. As you can see, everybody in the audience, we've got really just a wonderful panel, very broad-based, lot of experience and a lot of different experiences as well. And so our objective today is to basically cover at a high level the emerging cyber law situation. So we want to recognize the broad scope in cyber laws and the regulations that people need to comply with, understand the basic similarities that all of these laws and regulations have in common, and then also the major differences. Very important is to understand the consequences of failure. That's the third objective. And the fourth is knowing the flip side of it. How do you turn the tables? How do you put the law on your side? So with that, we'll be talking about compliance and consequences, state, federal laws and regulations, et cetera, and then the protection, sensitive business information, protecting that, intellectual property, vendor contracts, cyber insurance, and then the whole question of when you're buying and selling a company. What do you have to be paying attention to there? So let's get started. Mike, why don't you kick off the discussion with an overview of kind of what these laws, regulations, all this stuff, where that's all going and headed.
Sure, Stan. So what you're seeing up on the slide are a variety of the most important and those regulations that significantly impact businesses in a whole range of sectors of the economy. They're too sort of extensive and vast to go into each and every one of them. But I think that there are some significant points that each of us who advise companies and those in an in-house capacity need to be aware of. First of all, your breach disclosure laws at the state level are rapidly changing and evolving. There are now breach laws in, I believe, 47 jurisdictions. I'm sure shortly we will have all 50 covered. The California Civil Code is usually considered to be the standard with respect to breach disclosure information and requirements. And of course, we also have the New York State regulations on financial service companies, which has had a significant impact on companies in the financial sector. And it requires that individual companies that operate in this particular field follow not only certain requirements with respect to disclosure, but also it starts to implement best practices and implement standards for best practices. And I think that you're seeing in a lot of these regulations that there is a move no longer to sort of amorphous best practice standards, but more specific standards that are going to affect your companies.
Very good. Who wants to jump in and kind of pick up the ball on that one? Yeah.
Well, I think there are a number. The data breach is very important, and I believe South Dakota just passed a law, so we're at 49 or 50 at this point.
Yeah, I've heard 50. Yeah,
and so it's becoming the law. The California law has been a model in two ways. One, it became a model for other states to follow, but it enabled the debate about cybersecurity to happen, because we were now learning about these breaches for the first time because of the law. The second thing, when I say it's a model, it really is. It has a template for how data breaches are to be disclosed, and other states have largely followed that.
I think one of the things to point out is that the data breach law relates only to a category of personal information as defined in these laws. It doesn't apply to other sorts of private information or proprietary information. And the other thing is that a lot of these laws in the United States are called sectoral laws because they relate to a particular sector. They are not general, comprehensive, apply to all categories of information, particularly as they pertain to privacy. So there are some exceptions to that, particularly with the FTC, which does regulate, or is potentially regulates, a large swath of the economy for unfair and deceptive trade practices. But as we'll see in Europe, things are quite different.
I think we can.
Go ahead, Tom.
Bennet?
No, go ahead.
I was just going to say we can probably divide these up into broader categories. We can think of the statutes. The company should always be thinking about the statutes that apply, typically state and typically relying on or referring to breach notification. Then we also have the specific regulations that may be in place, often at the federal level, but sometimes at the state level, as we see in New York regulations. And often that applies to a specific specific businesses or business industries. And we should also be thinking about our industry, our trade group, who are best fit, from which best practices may be inferred. So,
and I just wanted, I'm sorry, Tom, I just wanted to add one thing with respect to the section and enforcement, and I'm curious as to other people's thoughts on this. I mean, a lot of clients still, even now that we're several years into breach notification, don't really understand that while they are a victim, certainly because they have been victimized and their information has been stolen, the enforcement entities, the FTC, the State Attorney General, certainly the PCI entities, they are there to scrutinize every aspect of how you conducted your breach notification, what types of standards you had in place, and they're going to look at every aspect of your information security policies to determine what your standard was at the point in time that the breach occurred. And so you're going to be investigated as to how you handled it and what you had in place.
And if you're a public company, you're also likely to have a securities lawsuit over whether or not you had adequately disclosed your risk. And so, yeah, it just compounds itself. And but the FTC has, in the absence of any national legislation, and the FTC through enforcement has been able to kind of set benchmarks for what is, sufficient or adequate data security because of their broad mandate to regulate anything that's unfair or deceptive in interstate commerce.
I should add that may also apply to private companies as well. Private companies with investors who may feel that they did not have the risk adequately disclosed to them.
So when we step back then from the specific, there's HIPAA, there's Gramm-Leach-Bliley, and so on, not looking at it as attorneys, but looking at it as practitioners, which is kind of the perspective I take. I'm seeing that all of these regulations, all of these laws, at one level or another, seem to hinge around 7 things. Senior management being involved, the presence of policies, the control of information, certainly training of staff, awareness training, and so on, management of third parties, a formal, rigorous IT security management component, and then having incident response business continuity plans. Talk a little bit about how the laws and regulations fit into these kinds of requirements. Yeah, maybe starting with you, Mike.
Well, I think what you're seeing is that senior management especially can no longer sort of rely upon outsourcing this to their IT, to their CIO or CISOs, and believe that the implementation of proper information security policy and management is simply going to be implemented through those mechanisms. Too often we're seeing in breach scenarios that while the information security side of the house may be implementing very sound information security policies, you may have a situation where, for example, the HR side is not fully integrated into that practice, and you see disconnections in the senior level management. And so I think what the regulations are trying to do is say, look, everyone has ownership over proper information security. And that's what certainly we preach with respect to the companies that we advise.
Mm-hmm. Yeah. Other thoughts on that?
Well, we're seeing in the New York regulation something that is much more prescriptive, that really is calling out the details of what a security program should be, which provides some guidance to the entities that are regulated. Generally, the preference in the U.S. has been for something like a kind of negligence standard, what is reasonable under the circumstances. But now you're getting some best practices that are being actually spelled out, which I think is, for some industries, quite welcome to have a little bit more meat on the bone as to what they need to do, because it's reasonable is a word that lawyers like to use, but it doesn't necessarily translate in many executives' minds to specific action items.
Yeah, the one thing I often focus on is it has to be a company-wide response to addressing these problems and minimizing the risk, and that the biggest risk factor that you can mitigate doesn't cost a lot of money in terms of getting hardware or consultants. It's recognizing that your greatest risk comes from your own employees. Someone clicking a link on an email they shouldn't. I mean, it turns out, you look at John Podesta, he clicked on a link and it's changed history. But, and the Sony hack, it was basically someone clicked on a link that gave access to the Sony information. And it's so just educating your workforce on how to be smart in today's cyber world is worth, as much as, high-priced consultants and any hardware you may get.
And I want to echo that with respect to Bennett's comments, because I think what we see too often is we see a lack of understanding of the importance of the data that companies are entrusted with from consumers. And that, to me, is a failure of top-level management to train employees to understand how to maintain and store and properly handle this information.
In other words, this needs to be a management priority. It needs to come from the top. From the top down, management needs to emphasize that this is a priority, and it just needs to be at the forefront of everyone's mind. You don't need to be completely paranoid about it, but it's definitely something that folks should be thinking about.
Yeah, that's what you're saying. In some ways, is a pointer to the very first webinar we had in the series. This today's being the fourth. That first one was on the importance of leadership in cybersecurity and talks so much about culture change. So for those of you who are listening who've not had a chance to see that very first episode, I encourage you, I invite you back and take a look at it, because what you're all saying just confirms the perspective we had in that first webinar, the importance of leadership, the importance of culture change. What are some of the consequences of failure that you're seeing? I mean, we've talked about FTC enforcement and so on. What kind of fines are companies getting? What kinds of settlements are they reaching with the FTC and so on in these kinds of situations?
Well, the FTC, it's kind of a one bite at the apple scenario, to the extent that they enter a consent decree with you, and then if you breach the consent decree, then you have fines, which can be substantial. But the first time with the FTC, you just get a consent decree, and you do have some onerous cost. There's usually an annual audit element to the consent decree, and obviously there's some publicity and financial, consequences of having entered into a consent decree. But in terms of fines directly from the FTC, you really have to be a repeat offender.
Fines are much more common with respect to the state attorneys general. I can tell you anecdotally that a couple of recent cases where we had situations with smaller companies, and this is something that I can't emphasize enough. I mean, a lot of the more mature companies, intermediate companies, they can withstand fines. But if you're looking at a smaller company where you may have less than 10 employees and you're looking at fines upward of $300,000 to $500,000, that could actually shut a business down. And we had to negotiate, very, very aggressively with them to basically beg them not to shut the business down. I will tell you that in California, that is not their intent, but unfortunately, that could be the collateral consequence. So for some businesses, the fines that are being imposed by the state attorney general could result in the business absolutely being shuttered.
And of course, there's always the possibility of private lawsuits, although plaintiffs' lawyers have not yet found, I think, the golden key for those lawsuits. They often are a major distraction and cause enormous expense as they're brought as class actions, typically against companies who have experienced major breaches, such as Yahoo, Home Depot, and the like. So that is an expense, and it may not be recoverable. It can be under insurance to some extent, but it's an expense, distraction, and bad publicity for the major offenders.
Yeah. Certainly.
If I could add just one point, one thing the FTC has been doing recently is they've been doing a roadshow in a lot of the startup hubs, Silicon Valley, Austin, some other places, and start with security. And for a lot of startups, they focus on their initial business concept, try to get it launched, and kind of along that move fast and break things ethos, and then security comes after. And they're trying to explain to startups that there are consequences of that. Not thinking of security, not thinking of privacy as part of the design, leads to you to having to be in a reactive mode. And you don't want to be in that mode, getting a call from the FTC, which is interesting because the caller ID just says U.S. government, and that's a daunting prospect to be in. And they want you to think about it from the start, and then you won't be getting that call.
Well, and people are coming up with these great gadgets, and they think about the wearables that seem to make our lives easier. But we need to understand that these are also, these are devices that rely upon the internet, which means that they rely upon the internet, that they're subject to security concerns. And we don't have to look very far. You look at the internet camera denial of service attacks that occurred with Dime, and how internet cameras are now being scrutinized for security. And all of these various different enforcement agencies are looking at these particular devices to see whether or not best practices were considered at the front end of the development of the product, as opposed to what they're trying to do now.
Yeah, and I'll jump in on that, as having earlier in my career been a security software engineer. We knew back in the 1980s even that you had to build security into whatever you were doing in technology. You couldn't plug it on as an afterthought at the end of that process. I want to move on a little bit. In part, Tim, it goes to what you talked about with the New York regs being proscriptive this way, which is different. In a sense, they've defined this is what you must do for security. Other laws, HIPAA has the security law or the security piece to it, the regulation, but a lot of the details are left to the attorneys and the practitioners to figure out, all of which leads to the question of what constitutes reasonable security. We have the California data breach report from 2016, I'm sorry, when Kamala Harris, now senator, was the attorney general, and she identified the Center for Internet Security's 20 controls as reasonable security, claiming in that document the failure to implement all the controls that apply to an organization's environment constitutes a lack of reasonable security. And I'd like to get your take on that, what that looks like to you, how this infuses your discussions with your clients.
Well, frequently clients are scratching their heads about what do you mean by reasonable security, and so typically these things don't come up in the abstract. They come up often in the specific context or in the context of a vendor agreement or the like, where there are some details that are provided. You don't sort of see agreement. You do see some references to commercially reasonable security under the circumstances, but then the question always comes back: what does that mean? And from my point of view, it was welcome that the Attorney General at least pointed to a source that I could refer my clients to as something that they can take a look at and see if those controls are appropriate. I think the danger is, of course, that these things get sort of placed into stone, and it becomes something that is not looked at as it should be in a dynamic way as to whether these are really necessary for certain organizations. So, I mean, it was a welcome event to have some specific guidance that was given for this, perhaps, and it's helped in the discussion. It's not the end of the discussion, however.
Good point. Good way to describe it. Yeah.
I may be a bit of a contrarian here, but I kind of like commercially reasonable security, at least in things like vendor agreements, because the alternative is to get some 6-page addendum filled with details that are impossible to fully satisfy. Hence, one could find oneself there. If there is some kind of issue, the company could be found liable, whereas otherwise the company could be fulfilling a commercially reasonable security standard.
I'm actually going to line up on
Tom's side.
Yeah, I'm going to line up on Tom's side on that one. I prefer the reasonable standard. I think that I think that there is a danger of these standards not sort of being specific to the industries that may be affected by these, and I think a lot of times you have standards that are not necessarily in line with the way that your business operates. So I would prefer more flexibility. I just prefer that management implements actual controls at a very early stage.
Mm-hmm. The agreements that I've seen where with details tend to be over lawyered, so a lawyer will throw the entire everything but the kitchen sink and then 2 kitchen sinks in addition to that, and one finds so much detail and granularity and things that we simply cannot possibly fulfill, and so one's in breach from the get-go.
Well, I agree with that, but because I'm often in the middle of that, because you are trying to negotiate from one point of view or another what that security should be. But ultimately, someone has to be able to discuss with a business what they need to actually do. And so with that, when you just have reasonable security out there, that's great, and it is flexible. But someone has to, at some point, sit down and speak to businesses and tell them what they actually have to do. So leaving aside the lawyering of it and the standards, how do we do that? How do you actually talk to businesses about what they need to implement? I think that's perhaps where Stan and our organization comes in, is to have something to point to. I understand we don't want to over-lawyer it and make it too specific or prescriptive, but someone has to tell people what they actually do. You can't just say, oh, maintain commercially reasonable security.
Well, yeah, and I agree with that, and I think that's a really good point. And you get into these debates with the internal CISOs and general counsel, you know, I'm a big believer that they need to do gap analysis or risk assessments on a fairly regular basis, which is a better and I think more unique and more tailored to the type of environment that you're dealing with. And I think that's, to me, that's preferable than sort of, you know, these prescribed standards. But
from a privacy policy perspective, there's often a throwaway line. We use, you know, best practices in security, reasonable security, state-of-the-art security, and people aren't aware that it's kind of like a throwaway marketing line, but people aren't aware that they can be held to that standard. And you're seeing enforcement actions by the FTC where people, you know, one, there was a recent enforcement action, the company said that we have bank-grade security, and they didn't. You know, it was completely, you know, just second rate. And that can lead to an enforcement action under, you know, the FTC Act. And so these type of phrases often are used as throwaway lines in marketing brochures and in privacy policies, but they have real consequences.
Interesting. I kind of see this again. I'm the practitioner here, not the attorney, and so I look at the first on it's on the screen, the Code of Basic IT Security Management Practices, which we developed here at SecureTheVillage with IT people, IT vendors, helping make sure that it was actually truly reasonable at a very minimum level. So if you do nothing else, do these kinds of, you know, you're at least on the IT security side. And when I look at, for example, the New York controls, the financial regulation, Tim, you describe them as prescriptive. They provide me as a practitioner a clear set of things that I must manage if I'm to meet the New York regulations. And to me, that's so much better than all the ambiguity that's implicit in just talking about reasonable security in that broad HIPAA, Gramm-Leach-Bliley, whatever kind of context. Again, that's perspective not from an attorney, but from the practitioner here. So let's go on to the next slide and kind of pick this one apart then. And this now shifts the discussion to privacy. Obviously, the big piece of privacy is GDPR right now. We get GDPR in this month now comes into play. Tim, you want to give us a brief overview of that?
Sure. This is a hard one to be too brief about, but I will attempt. GDPR is the European Union's general data protection regulation. And why should we be concerned about that in the United States? Well, for several reasons. This applies to any company which targets consumers, which are called data subjects in the European Union. So what we're finding is that many companies who have sell through to Europeans from the United States are affected by this. But even more, it also affects those who process data of European data subjects in the United States. So many software as a service companies and other vendors are finding that they can fall within the extraterritorial effect of the GDPR. And what's different about the GDPR is that it is a general data protection regulation. It is based on the fundamental right of privacy that exists in the European Union. It requires reasons to be articulated and to process the data of Europeans, and it applies to a very broad range of data related to individual data subjects. In the United States, we typically define personal information in several narrow categories, but the European have a very different approach. They look at all the bits and pieces of information that can relate to an identifiable individual and require that there be a consent or another legitimate means of processing for that data. It takes really privacy very seriously, and there are reasons why the Europeans do this, of course, that relates to history, but it takes it seriously in a way that has only recently, I think, become a matter of active debate in the United States, and we'll talk about that in a moment. The consequences of not adhering to the General Data Protection Regulation can be quite severe. from May 25th, the data protection authorities in the European Union member states will have the ability to levy very substantial fines and penalties, something that they do not have today. Another thing that is important about this, it's very closely related, is that the Europeans do not prohibit the transfer or for processing of data from the European Union to countries that are not deemed adequate. There are very few countries that are deemed adequate, and you should probably understand right away that the United States is not considered a country that is deemed adequate in terms of its privacy laws, partly because we don't have a comprehensive privacy law, and partly because the Europeans are deeply suspicious after the Snowden revelations of what happens in terms of access of the government to data here. So in order for companies in the United States who process data of Europeans, we're seeing a large number of vendor agreements that are coming down in which companies in the United States are being asked to sign on to protect the data of Europeans in the way that it is protected in Europe, and to sign on to some sort of a transfer mechanism. And that can be either through joining the Privacy Shield arrangement between the EU and the US, or signing on to protect data through standard contractual clauses. So there is going to be something like litmus. Well, I'm trying to think of the right analogy here, but what we're seeing is that many companies in the United States are having to sign on to European standards. And so this is having an effect as they pass those standards on to their vendors and processors. And we're seeing European concepts of privacy, which is a much stricter right of privacy that takes privacy very seriously and does not define it into narrow categories. This is coming more and more to companies in the United States, and I think is going to have the effect of stimulating a debate as to how we protect privacy versus how the Europeans protect privacy. So that just touches on a few of the aspects of the GDPR, but we're going to see, it remains to be seen how broad an effect it will have in the United States, but we're already seeing a lot of companies being forced to sign on to European standards and how they protect the rights of data subjects in the European Union, how they protect information. There is a small security component to the GDPR, but it really doesn't advance the ball very much beyond what we have here in the United States, except that it does require that data breaches be reported within 72 hours of the data breach. So that potentially is going to be have a major effect on how companies in the United States who are subject to a data breach report to those whose data has been affected. So that's a very brief overview of it.
Good, thank you, and jump in. The rest of you as well.
Bennet, one thing that's interesting about what's going on with the GDPR is it is sparking a debate, and coinciding with the Facebook Cambridge Analytica scandal, and one of the questions being asked is, do we need a European GDPR type law in the United States? And so for the first time, you're seeing privacy actually being debated in Washington. And it's interesting. My radio show, we just had our 300th show. And so I was looking back at early shows that we did in 2011, and they were on bills pending in Congress, on privacy. And what's interesting is after 2011, the debate on privacy just died. And so privacy is being debated for the first time now in 7 years because of Facebook, because of GDPR. And so I'm not saying anything's going to happen anytime soon, just because of the number of players involved to try to achieve a solution. But it is front of mind now for a lot of people.
Mm-hmm. Does that even include the crossing of party lines, Bennet?
I think to a certain extent. I mean, there's actually a bipartisan bill that was just introduced and after the Facebook scandal, but it's unclear if it's getting any traction. But yeah, I mean, there are some Republicans who are, they're consumers as well, and a lot of people are concerned about the Facebook scandal, and so it's not something that is as partisan as other issues, but there is kind of a tendency on the Republican side to try to protect businesses from liability for privacy.
But it goes even beyond Facebook. It goes to the data breaches that have occurred lately, that involve the data of hundreds of millions of people in some instances that have been debated in Congress. And, is there any real teeth to the current data protection in the United States when your information can be sold onto the black web or purchased on the black web? And there's been actual discussion whether we need to have real fines and penalties for data breaches as opposed to the system that we have now. And so it all is coming together with consumers very concerned about their data, and they don't really care whether it's in a narrow category of personal information. They're concerned that people can compile profiles of them from bits and pieces of their likes and dislikes, or sell their information into the black web through a data broker, such as we've seen in the last year.
Mm-hmm. And I think Tim's point is very important, which is that, what we're seeing is it's not just of the PII, the personal identifiable information, credit card information, social security numbers, that we've seen historically. We're now seeing a move, especially with Cambridge Analytica, that demonstrates that people's profiles, their likes, their dislikes, how they shop, what they like to read, those types of things have value as well. And so it's the much more private side of an individual's sort of viewing habits that are now being consumed for purposes that are completely outside of what they ever agreed to when they signed up for a Facebook subscription.
Isn't there a fundamental tension here, though, that really goes to the business models that each of these companies employs, and it gives us a chicken and the egg problem? Consumers may be concerned about disclosure of their privacy, but are they concerned enough to pay Facebook $20 or $30 a month for Facebook services? Are they so concerned that they're willing to pay Google $30, $40 a month so that they can find everything on the internet, so that they can find a map to get home and save a couple of minutes when they drive home, and so on? And I think the jury is out on that. I think that these consumers have been conditioned to the idea that everything is free and should be free on the internet. And when we go with that assumption, these companies are going to have to make money somehow, and it's by, in part, through advertising, and advertising somehow involves increasing disclosure or availability of personal information. I wouldn't necessarily say disclosure, as well as release of personal information, the information that could be considered private.
A couple of years ago, there was a UK game company, I think it was called GameStop. They did an April Fool's joke. Obviously, the lawyers had a little too much time on their hands, and they changed their terms and conditions for April Fool's. And you had the option of opting out of the terms and conditions, and they would give you £5, $10. Or if you didn't opt out, you actually granted to them in perpetuity an option to purchase your soul for eternity. Which they then had this elaborate mechanism where they could exercise that option with flaming letters on your lawn. But the point is, even with the option to get $10 by opting out, only 12% of the users did.
In other words, you're saying they took they turned down the money.
Or 12% of the users took the money, mm-hmm. And the other 88, have sold their soul.
Sold their soul. Yep.
I think there are a lot of Facebook users who've done that for free. But I guess is I understand Tom's point, but I think that the need for transparency, this is going to come perhaps not from a popular uprising of Facebook users, but perhaps from regulators. I'm waiting to see what the FTC is going to do about this situation, because Facebook has been dinged before. So this time they have the possibility of really ding through a consent decree, but now they have the possibility of coming in with an actual fine or penalty. And I think that the European pressure here is going to force changes in these organizations, of the big social media organizations, because they are the ones who are in the radar of the European regulators. Facebook has been for many, many years. It's led to some validating an entire transfer mechanism to the United States of data, the safe harbor. So I think we're going to see whether people are willing to put up money for a service or not. We're going to see changes here that are forced by regulators in the European Union that are going to have effect in the United States. And also the FTC, I think, is going to come in here because it is a bipartisan issue. There's now a full slate of commissioners, I think, at the FTC. Yes. And I suspect that they're going to act on the Facebook situation.
It's not going to come from Congress, that's for sure, because it was clear.
Mike, your mic just went out.
Oh,
there you go.
I was just going to say that I believe that it would have to come from a regulator like the FTC and not Congress, because it's clear that Congress does not understand how Facebook even functions.
And that's a shame, because taxation, I hate to sound too libertarian about this, but taxation would seem to be one of the simplest mechanisms to get to this and force companies to adjust their business models. That is by increasing taxes on use and transfer of private information.
Interesting.
It's definitely going to be difficult to see a point where we have people voting with their feet. I think Tom's point's well taken, but at the same time, there is a growing sense of, I guess, maybe disquiet about what is going on. And the example I would give is Tim Berners-Lee, the founder of the World Wide Web, last month or 2 months ago published an announcement that now over 50% of the world is hooked up to the World Wide Web. And the second sentence was, given what's going on now, will the other half want to? Not whether we can achieve it, but will they want to? And I thought that was striking.
Mm-hmm. Yeah, fascinating. Let's go on. Let's move on from this topic. Now, change the subject, turn the tables, if you will. Shift the discussion from, okay, we've got to comply with this or that or the other set of rules. Now, what are the rules that we want to negotiate to protect our organization and our information? So it turns around. Now it's looking at things like sensitive business information, intellectual property. How do we protect it? We, a company, a nonprofit, a small business, a mid-market business, a Fortune 100 even. Tom, you want to start this discussion with your emphasis on IP? Tom, your mic's... Sorry
about that. The gardener's gone crazy with the leaf blower. Part of it, company has to look at all of its relationships, both its internal relationships, which includes your employees, and you also need to look at your external relationships, your dealings with all of your vendors. Your dealings with your employees, you need to have proper contractual relations in place, as well as ongoing training. And again, the emphasis needs to come from the top that this should be regarded as a priority. In terms of relations with all of your external relations, your dealings with vendors, every single vendor can be a problem either way. And so we need to be looking very carefully at the agreements that we have in place with our vendors, have appropriate safeguards in those agreements, which are your contractual backstops, but you also need to follow that up by determining what kind of security is provided by vendors to whom one entrusts private information or who may be gathering private information on one's behalf. Indemnification is also critical in these relationships. If you're using a credit card processor, for example, or have some other third party that's gathering information on your gathering or processing, private information on your behalf, you need to have appropriate indemnification in place. Moreover, your insurance plays a critical role. And insurance is something that you need to look over very carefully with your insurance broker. We have insurance brokers who are members of SecureTheVillage, and they're really great resources in terms of finding gotchas that may be in an cyber insurance policy. So that's what that's a kind of a top level view of what we need to be thinking about in terms of a company.
Let me just add something, Stan, that I think is really important. And
your mic is there. You go.
Okay, Howard Miller will type something into the chat line. Cyber insurance, we've seen this in a number of instances very recently with clients. One size does not fit all. You really need to look at your policy, determine what are your deductibles? What does it cover? Is it just third-party intrusions? Does it cover third-party email compromises from some external source? What does it provide you with in terms of your incident responders? Does it guide you to specific incident responders? Do you know who those people are? Those are all things that insurance policies in the cyber realm now sort of dictate, and you must look at. It's not just something you buy it once, pay for it, and figure you've got it in your back pocket.
Yeah, that's one of the things I've seen, again, is from the operational side, making sure that the terms and conditions of a policy are actually feasible. I once reviewed a policy that would only cover cyber breaches, crimes, things like that, if the policy holder kept their systems 100% patched. And as a practitioner, I've never seen a system with everything 100% patched. It's nearly impossible to achieve, and it would definitely interfere with the business, running of the business, where IT to be that aggressive at patching. So, like, to me, that's, again, one of those things that when one's looking at cybersecurity insurance, and you're the attorneys, you're used to paying attention to the devil being in the details this way. But it's certainly the case that you need that really rigorous review of cyber policies. That's part of what we see.
What you're pointing to is that not everyone needs to be an expert on cybersecurity, all of your attorneys and management, but they at least need to be conversant in the issue of cybersecurity.
Yeah. The other thing is that the threats are evolving, so that not every policy is really meets the current threats that are prevalent. I mean, you think of ransomware or good old-fashioned fraud, convincing a company to send money to sort of an entity overseas because someone has impersonated the CEO or CFO. Those sorts of threats, you have to think of what is the threat landscape like out there? How is it evolving? And will my costs, my downtime be covered? Will I be able to recover money that is transferred out? There are many different factors that you have to look at and see what is realistic for your type of business and what kind of threats that you face.
Mm-hmm. Yeah. So let's look at this question then. We've got information we've got to protect. It could be that it's other people's information that comes to us, healthcare or whatever. It could be our own intellectual property. Now, we have vendors with whom we share information. What do you have to insist? What do you want to make sure are covered in those vendor agreements? We kind of touched on this kind of piecemeal a little bit here and there over the course of the morning, but just more succinctly, more kind of organizationally, what's got to be in those vendor agreements?
Well, they typically have confidentiality provisions in. They typically have an allocation of risk in regards to what is how they're processing information in terms of potentially insurance requirements in them as well, and in terms of reporting of data breaches, they have to have that. They also need to include indemnity provisions in many instances, and then there's usually a fight over what the standard of security needs to be that I think Tom talked about. Sometimes it depends on your point of view. Some days that I'm asking the vendors to maintain specific security controls, and other times I'm representing the vendor and fighting back against those. But there's a bit of a tug of war going on. But you have to also make sure that that your vendors have the potential of being audited in the event that their security is found lacking, that they consider the sensitivity of information. Sometimes you want them to segregate the information if it's highly sensitive, and generally you want to avoid having a weak link in the chain. And so there's often a tug of war back and forth. And I represent both vendors and companies who contract with vendors, so I've seen it from both points of view. But it's, again, the devil is in the details, and there's often a fight back and forth as to what that should be. You should be very concerned about a vendor that just will sign anything that you put in front of them. That makes it easy, but it often means that they have not really thought through what's going on.
And Tim makes a good point, because what's going on now with, I'm reviewing a lot of HIPAA vendor agreements, and now you have GDPR vendor agreements. I think it's going to spur an increased awareness and sensitivity to it. And hopefully by having to sign all these agreements, companies are reviewing their practices and having a discussion with their lawyers, with their IT people, to make sure that this is something they can really sign on to.
One of the things that, go ahead, Dan, I didn't mean to cut you off. One of the things I'd like to mention is that this comes up all the time in confidentiality agreements and in provisions within confidentiality provisions within larger agreements. There's often a vanity aspect where one side wants to make these obligations mutual. And we should always understand that there's a purpose, there's a real purpose to these confidentiality provisions. And whenever you create, you have to be careful about making these obligations mutual, because you don't want the company to be burdened by a bunch of obligations that are really unworkable. On the other hand, you need to strike a balance and make sure that your vendor is complying with appropriate, with the appropriate standard of care. So it's not, that often folks will say, I have all this confidential information, you need to protect all my information. That is often overstated, and we need to be cautious about incurring unnecessary obligations on the company's part.
Mm-hmm. Let's finish this section with a brief discussion of when you're involved in a merger and acquisition on either side of the table. And again, there's both sides of that. What are some of the kinds of things you want to pay attention to?
Well, obviously, you want to be thinking about what kind of exposure, if you're acquiring a company, and you should be thinking about both sides. You want to be thinking about what kinds of data the company may be maintaining, and what kind of exposure that company may have, because you could be buying a lot of exposure that's unnecessary and certainly undesired. And we certainly saw this in Yahoo, the Verizon Yahoo acquisition. That's a perfect example of how a company could be acquiring a lot of liability that they don't necessarily want to have, and that brought the price way down, as we all know.
Yeah.
You see a lot of legacy. You see a lot of legacy systems in companies that are being acquired that may have very serious security vulnerabilities in them. You may not fully understand what information, what very significant personal identification information exists within those systems. So it's critical for an acquiring business to go through the network and to provide a very thorough network assessment and security assessment of where the acquired company is with respect to their network and how they've segregated very critical information.
And two things that also come up. One is, can you show the history of your data, how you got it, And did you have consent to get that data? That's coming up, and being able to document that you have the right to use that data is becoming increasingly important. And then one thing that GDPR is stimulating is a discussion about how long do you hold on to that data. GDPR really wants you to hold on to it only as long as you need it, whereas a lot of tendencies with U.S. companies is to hold on to data forever.
And Bennet, there's also the issue of whether you can transfer the data under the GDPR potentially, so that it's not considered something that is under the GDPR that you can just freely transfer to anyone who's not going to undertake the same responsibilities as the entity that originally collected it. So there's going to be issues there, and those who process the data too can't just simply sort of pass it on to another party to do sub-processing without making sure that they follow through on the same effect. So I think the GDPR again is going to have this effect, a reverberating effect, potentially through how companies respect the data and minimize it and do all the things, because you have to be responsive to the data subjects who may have complaints or inquiries or even want the data erased. The so-called right to be forgotten could play into this.
And Tim is pointing to a really important point about the GDPR, namely the legal protections that we usually think about, the contractual protections, the indemnifications. Those don't necessarily protect you from GDPR exposure, GDPR liability.
Okay, fascinating. We're pretty close to being out of time. Any final thoughts you have before I kind of wrap it up? I'm hearing a lot of GDPR, kind of that's the 800-pound gorilla on its way.
The 25th.
Yeah, the
yes,
25th. Yeah.
But it's probably not going to be the end of the world immediately, but because it'll take a while for the data protection authorities to start paying attention to it. But it's worth thinking about, because I think it may be a sea change conceptually. I'm not sure that every company is going to be subject to fines and penalties by any means, because they're limited resources. But it's a new way of looking at the world. It's been coming for some time, and it may have a bigger effect. Not the end of the world, but I think it's an opportunity to think constructively about these issues and what's important.
I think a little maybe less dystopian, not the end of the world. It's the beginning of a new world where privacy takes on a new meaning for us. So,
yeah, and we haven't even talked about the fact that under GDPR, every company has to have a DPO, a data protection officer, and that person is the person with respect to responsibility for all aspects of GDPR. Fines, even possible jail time under certain circumstances are real prospects under GDPR that the DPOs are really going to be in the crossfire on.
Interesting.
That's for anyone that's regularly processing or collecting substantial amounts of data, and it's unclear exactly what that means. It's probably not the incidental person who sells a few garments to people in the European Union, but it's going to affect a very, very broad number of companies.
And CPOs are one of the fastest growing members of the C-suite. And I think as their population grows, you're going to have greater awareness, greater discussion about privacy at companies, across the country.
Certainly, much the way the CISO role it's gotten up towards the C-suite is impacting dialogue there as well. Definitely. Well, let me thank all four of you for just a fabulous discussion. Let me move on to where we're going next. Next month, June 7th, we'll be talking about information security policies and standards. And you can register at SecureTheVillage.org. My guest will be a mystery surprise. We'll have that available somewhere in the next week or so. We'll get that out to everybody as well. This is part of our webinar series designed to provide management guidance, practical, real-world, how-to, and actionable. They The webinar series ties into the Secure the Village resource kit, which is available off the Secure the Village website. Our webinars are the first Thursday of each month at 10 a.m. Pacific. Here's the calendar of all of the webinars we've had so far. We said this is our fourth, the basics of cyber law. June 7th, we'll have information security policies and standards. And the the schedule is laid out through January of 2019, when we'll have a more focused discussion on cyber risk and insurance, more focused in the touching on it that we did today. Secure the Village, our whole intent is to turn people and organizations into cyber guardians, able to navigate through the security challenges, the privacy challenges that we have. We have our monthly webinar series, executive focus groups. We have our resource kit, the Code of Basic IT Practices, which we touched on a little bit today, and then community-based programs, actual events not on the internet, but out in the, quote, real world, both for businesses, organizations, and also for the broader community and so on. For more information, here's contact information for the panelists and for me, our phone numbers and our email addresses. Feel free to reach out to any of us. As you can tell, we've got a certain passion for cybersecurity and have a real commitment to helping the community make things happen. I mean, the people you've been listening to today are all on the Secure the Village leadership panel, and they're just an illustration of the kind of quality that the panel, the Leadership Council, represents. So I encourage you to reach out to my panelists and take a look at the Secure the Village website as well. With that, I want to thank everybody for attending, and with that, we are adjourned. Bye, all.
Bye. Thank you, everyone.
Thank you.
Thank you.
Thanks.